So in California, we have an immunity statute that says if I'm serving as a volunteer to a nonprofit, I mean, it can apply to associations, but it works better with corporate. I'm used to the corporate structure. Then if I'm not paid a salary, and that does, I can still be paid for expenses, I can even still get a small stipend, but if I'm not paid a salary, then I am personally exempt from liability under both state and federal law. So it's a good reason to consider protecting yourself and, more importantly, protecting the volunteers who serve in your various ministries and other organizations.
So you said that does or does not apply to associations?
It can, but it works a lot smoother in a corporate. I believe that, and again, based on the 40 years I've been doing this, that the reason you incorporate as a nonprofit is primarily to provide for succession. Because once you form the corporation, again, it's considered a legal person, and obviously people come and go. But at our church, our pastor of 35 years retired. We haven't missed a beat, right? Because we, again, getting into a separate discussion item for later, we had a succession plan that worked very, very well. But the corporation itself remains in existence, and it doesn't miss a beat. So that, to me, assuming all of you want your churches to grow, prosper, and go past the current leadership, it makes sense to do that. You had another question?
Yeah, so on our board, we have 4 non-paid members. We're a corporation. 2 on that board, elder board, are paid
Staff.
Pastors and pastors. Are those 2 paid staff liable?
Maybe. Liable means you're guilty.
Guilty.
So
So,
there's exposure, and then there's actual liability.
so we do have insurance,
Then you're probably okay.
so those guys probably are okay.
Yeah.
All right.
And again, there's also, you split it up because in some cases it depends on what they're doing. If I'm serving as a paid staff person at my church, but I'm also serving as a volunteer, we go to a men's retreat and I'm volunteering to do something, that could be a different scenario. It's always got to be analyzed to determine where liability might arise. So it gets kind of complicated. But to me, going back to the main issue, if you incorporate, probably in better shape, and then make sure you have the appropriate amount of insurance. Bob was 100% correct. I spent a lot of time dealing with insurance issues, and you always want to think about it. I was on a panel a couple of weeks ago, and the attorney that was, he's an insurance specialist, and he made a great point that you not only want to analyze the insurance that you need at the top end, but what can you afford to self-insure for at the bottom end. In other words, you're going to have a deductible. So, some people look at the deductible and go, let's make it as small as we possibly can. But on the other hand, the insurance premiums that you're going to pay for various things could depend upon how much you could afford to pay as a self-insured. So there's those kinds of issues as well.
Yeah, the other thing I think as well, I mean, John and I both work a lot with real estate. One of the big issues with an unincorporated association is it's more difficult to do business, basically. I mean, to purchase real estate, for instance, it's like it's that group of people purchasing it, as opposed to this corporation, which may and probably would have personal guarantees by some of those people. But banks, lenders are a lot more willing to deal with corporations. They understand corporations. If you're just a group of people that is calling yourself a church, and you very well may be meeting all the requirements to be a church, they don't understand that world as well as they do corporations. So I think just for ease of use, John hit on it for sure, the succession.
To me, when I look at businesses that are looking to grow, or nonprofits that are looking to grow, the corporate structure, because we're not all going to be around, we all have a shelf life, right? God's going to decide that. So the bottom line is we're either going to retire, become disabled, move away, or pass away, in which case the church goes with us, particularly if we're a key person. That's why I keep coming back to the succession. The other question that's raised here, which I think is valid, and it's really, I guess, up to the individual organization, is it a pastor-run board? Is it going to be an executive? How are you going to handle your governance in terms of the day-to-day and the month-to-month, and who's doing the policies? A lot of churches have. So that's something we can talk about if you have any questions about that. We all have biases. I have mine. Share that with you, Mike. Apparently I'm going to because I'm going to be asked a question.
When a church growing, increasing in people, and then also operate some associated business like Christian school, daycare, whatever, or a seminary, growing enough, they want to provide some kind of counseling service. So the way they try to avoid the liability of, to protect the entity is to form a separate, corporation, Christian school, after daycares, after school entity or counseling service. And with that ultimately, if the church still have a control, it's control test, so-called, the denomination or the parent company, would that be held responsible if something happened in this counseling service corporation or in the Christian school after daycare, the after school daycare? If something happened, would the parent church or seminary be held responsible?
Let me give you the best lawyer-like response I possibly can. It depends. And it really does, because let me give you, and so using your example, so I've got a church, we've done well, we've decided to start a preschool, maybe with an idea that the preschool would add a grade a year or a grade every other year to become a full-on high school at some juncture down the road, or maybe we've decided to start spinning off some other entity because we're getting unrelated church income that could be construed as a business per se. The question then becomes, you mentioned control. If the control is so powerful that there really is no distinction between the two entities. Let me give you the example of a church that starts a school, and we've seen many of them around. I think Linfield is standalone, but we have Rancho Community, we've got Crossroads down the road here, and there's a bunch of others, I'm sure. If you form a separate entity, let me give an example that I'm familiar with. A lot of my corporations that are nonprofit also have foundations that they operate for charitable purposes. What we've done over the years is, as quickly as we can, set up their own boards. And now you end up with liaisons going back and forth. It just depends what's comfortable. Obviously, the pastor can have a lot to say about that because he or she's going to want to be, have a say in all of that. But it just depends. You could be held liable if there was a negligent act that caused somebody some damage, and it was shown that the subsidiary was really nothing more than on a puppet string for the main entity. So if you're blessed with the point where you're actually looking at doing something like that, you need to sit down and really think through how you want to set that up so that if your purpose is to try and protect yourself from liability, churches certainly that have schools, clearly that's an issue. And just to be clear, if you form a DBA, your ABC church, and the preschool is going to be XYZ preschool, and it's just a DBA, a fictitious business name, it's the same. There is no distinction between the two. Whereas if you spin off the preschool, say for example, or whatever it might be, into a separate entity, and you handle it correctly, and good counseling from lawyers and CPAs and that kind, because there's tax issues obviously, then yeah, you would probably be okay. And you could protect one from the other.
Let's say there's two separate board members,
Okay.
and maybe some overlapping.
Okay.
But there's one other provision that says that counseling center director or the after-school daycare principal need to be approved. I mean, you could select someone, but need to be approved by the church. Something like that. Would that make
Probably
it?
not. I don't think that in and of itself would be sufficient to pierce through the one veil to get at the other. I think it'd be, again, a lot of it has to do with how you structure, the pain in the neck part of running a corporation is you gotta do minutes. You gotta have regular meetings. You gotta maintain what we call that separate identity, right, between me and whatever the corporation. So if you have the two, and it's merely an approval, or even an appointment, I don't think in and of itself that would be sufficient to cause a problem. Yes, sir?
We have an association of 3 separate churches that has formed a nonprofit religious corporation to operate K through 8 and preschools.
Okay.
One of the 3 churches is an association, the other 2 are corporations. Does that cause any issue?
For the one that's an association, it certainly could. From a management standpoint, it's nothing more than the three entities, whatever they are holding entity for the 4th entity, which is the preschool school. So, as far as liability, again, liability is a term that you guys use, right? It really boils down to, has there been a legal obligation that someone had, and the allegation is you fell below the standard of care, okay? And if so, did that cause damages? So those are the 4 elements: duty, breach, causation, damage. If there's been a duty that's been breached, then the question is, where does it go from there? And unfortunately, that means somebody like Todd or I has to come in and take a look at that. And then, of course, your insurance then picks up the tab for it.
Yeah, and there's no like black letter, here's where exposure becomes a factor and here's where it doesn't. It's just a whole bunch of factors that the court would look at to determine, is this a valid, separately operating entity from these people or from this other entity? And when you hit on one, it's like if the board is different, or if there's a different location, or if they would have their own bylaws. I mean, I don't know if everybody understand. I mean, we can go into that as well about bylaws, but the bylaws are kind of the operating rules of the entity, the corporation.
Right.
If that's different, and if that's different and the board's different, all those things move towards keeping the veil in place. If the board's the same and they've used the same bylaws that have just been slightly changed, I mean, all those things are going to factor in.
Yeah. In our case, we have a separate constitution and separate bylaws from all 3 of the congregations. One thing that we do, though, is we are leasing space from one of the congregations for classrooms.
How long is this? Is it a relatively arm's length transaction? In other words, let's say I wanted to start a business in here and I would lease space from Azusa Pacific, okay?
Mm-hmm.
If it's an arm's length transaction, I'm paying reasonably fair rental value. It doesn't have to be dollar for dollar, but something that's clearly not a giveaway. If it's a properly documented transaction, that's probably okay too.
Okay.
It's just, again, I hate to say, lawyers get accused all the time of ignoring or evading, but the reality is, it really does depend on the circumstances. But if it's set up properly and then run properly, you're usually going to be okay. And as Todd said, then you get into all sorts of good reasons why you want to do that. Right? You can buy, you start a church, you're renting space in a school or somewhere like that. You finally get to the point where you can afford to buy some property to move forward with your own property. Either you're going to buy it individually or you're going to buy it through a corporate entity. Now, whether there's going to be a personal guarantee on the debt or not, that's another issue. And then, of course, you get into what I think is a key issue, only because I've been through it so many times, is succession, right? You don't have a plan. Let's face it, most of the time in many churches, the head pastor, the executive, whatever you're calling that head pastor, is the guy, right? And if that person is taken away, I know at our church, that was a huge issue. And in a number of other things I've done, I had a corporate client up in Orange County, and the woman that ran it was a legend in her, a legend. And so you're starting to think, okay, she's 70 years old now. Our pastor was 70 years old. What's the plan for dealing with the inevitable situation, whether it's retirement, which is typical, or God forbid something else? And so the corporate structure allows you to do that in a much more organized fashion. You got to do it. I believe personally that it's the fiduciary obligation of the people in charge, the board of elders, the church council, whatever it's called, to plan that. Because even if it's a young pastor, like our pastor right now, by my standards is very young, he's barely 50, right, he's a kid. Yeah.
He's a rookie.
He's a rookie, exactly. He's still got wet behind the ears. But the fact is that we're all mortal. And so if something were to happen to him, I'm not sure what the succession plan is now, but we did a really good job of succession planning for our senior pastor, who's pretty much started the church and built it from scratch. So, and the same with that other company, they designated someone, and then you spend a long period of time, 3 years, whatever, doing that succession, right? Because, for example, my clients, I'm their lawyer, I've been their lawyer for, some cases 30, 40 years. Well, at some juncture, I'm not gonna be their lawyer, no matter what happens, right? And so you start getting people used to the fact that somebody else, and how you do that in a church structure is by starting that person taking over that first year, maybe taking more and more responsibility, so people start getting used to that face, used to that, that, because none of us are gonna do things the same way the last time. It's never gonna happen. You can be similar, but you're never gonna be the same. And then over the course of time, you start seeing the metamorphosis into where by the third year, I remember got a phone call from a particular client in Orange County, and she wasn't feeling particularly good because she says to me, I don't feel like I'm earning my money because everybody's going to the new guy. And I said, then you did exactly what we planned 3 years ago. It's working exactly the way we hoped it worked. But you can't do, but again, in the corporate structure, that makes, it makes it a lot easier to do that. So,
I have a question about
Yes,
what we
ma'am.
talked about earlier. So we're a religious corporation. We have a subsidiary that's a public benefit. And in most ways, I mean, it's different bylaws, all that kind of stuff. The board, we have different board meetings. It's actually the same members, but they're two different boards.
That's probably gonna be okay at the beginning. It works, it becomes too much, if things go well and everything becomes very successful at both ends, then it becomes too much to ask volunteers to do, and that's when you start thinking about maybe having some different people on the two boards so that you have, again,
Sure.
people have limited time. But no, that's, from a legal standpoint, I don't think there's a problem.
No,
So
I-
you should keep them separate.
Yeah, I agree, and John's like hit on it multiple times too, that it's like, there's a lot of, it depends.
Yeah.
I'll tell you though, that it's like, if I'm representing the side that's trying to go after one of those boards, I'm gonna be looking for anything I can see that shows that those two boards are basically the same, and that those entities are the same. If I see the entities have the same boards, I'm gonna bring it up.
Yeah,
Whether
you
that's
raise
gonna
it.
succeed or not, that's the it depends. But they're gonna be looking for anything they can show that shows that they're the same.
But you kind of almost answered your own question, and then which is that separate boards, separate meetings. All of us have watched city council meetings where they adjourn out of one sort of title into another title. It's exactly that.
That's what we do, yeah.
You can, the foundations that I was talking about, they would adjourn right in, and they would keep a separate set of minutes, and then as things went well, they would start thinking about adding people on so that you could end up with a more focused group of people for the two different entities. But that's the good planning part. That means you've done well. But at the beginning, no. As long as you do what Todd just said, you keep separate minutes. You make it very clear that the meeting is going to be at this time versus this, and a lot of it is just form over substance, right? We're doing this so that some lawyer like Todd isn't going to be able to pierce through that corporate veil. And again, there's 4 reasons that you can pierce. Number 1, it isn't set up properly. That's the lawyer's problem. You got a malpractice claim most of the time. Number 2, it's not properly capitalized. Well, if you're down the line, that horse is already out of that crowd, because that usually is like the first year or two, where you're not able to pay your bills for that first year or two. And then in sort of combined is really the corporate maintenance issue. I can't tell you how many times I've gotten somebody in and all they have is a corporate kit, right? They have no minutes, no annual meetings, no elections, and you're sitting here with nothing, right? That's not, so somebody needs to be in charge of keeping, I own a separate business, and I'm the secretary, so it's my function every month to keep minutes. And then we have an actual history of the organization. And that's important. People tend to not think about minutes, but it really is important because frankly, it's also important because it's the history of the organization, right? If I come to what's the name of your church? I can't
The
read.
Garden Fellowship.
Okay, if I go to the Garden Fellowship and I become a member of the board, the easiest thing is if I want to know what's going on, give me, a couple of years worth of minutes and I can see what's actually transpired, which brings me up to speed fairly quickly. Yes, sir.
In her case, the religious corporation has a property tax exemption. Does the public benefit corporation dilute that?
I don't know.
I mean, because
That's
it's
just-
a non-religious use of their religious property, that their umbrella is, you've got a tax exemption, you don't have to pay property taxes on your property because you're a religious corporation. But if you have a non-religious use of the property, I'm wondering if that,
Yeah, that's where you would sit down with an accountant. Sometimes, frankly, your accountant is more important than your lawyer. Most people don't think we're important until there's a problem. But the reality is that you'd want to always sit down whenever you're thinking about spinning anything off, whatever it is, or doing anything like that. You want to make sure your accountant and your insurance people are also brought into that mix so that there's proper insurance. I represent a lot of realtors, and they don't understand, they have malpractice insurance. But if I have an open house and somebody comes in and slips and falls, that's not malpractice insurance, that's general liability. So you want to have your insurance person, understand that if I have a preschool, for example, that's a different kind of insurance than I might have over here. You have building insurance, you have, Bob mentioned cybersecurity insurance. If this bill passes, the 30 bills that are sort of the privacy law, we're all going to want to look at that. Websites are starting to get attacked now as being something that you could be liable for. So cybersecurity insurance is something we hadn't thought about 5 years ago, right? You're going to want to start looking at that. So talking to those people, the accountant and the insurance person, makes a lot of sense. But they're going to turn around and tell you it's a lot easier to insure the corporate structure than it would be the individual association. You have a question, sir?
I'll pass that.
Okay.
Does everybody, John was just talking about like the minutes and that type of thing. Does everybody understand, we're here to talk about it. So does everybody understand basically the documents that are used in a corporation? How it's set up, what the minutes are that he's talking about, or should we hit on any of that?
They don't know what they don't know, right?
Well,
No,
we'll just run through it very quickly.
Well, you
the-
mentioned annual meetings. Is there any way to eliminate annual meetings? Or,
Probably not a good idea if you're going to have an election.
if you dissolve the corporation, you can eliminate your.
well, I was just thinking
Yeah.
this.
You're a closed corporation, you can eliminate a lot of the meetings, but generally speaking, you're not gonna be a closed corporation. Therefore, you're probably gonna wanna have an annual meeting, which in some cases may be the only meeting that you really have all year. Our church has an annual meeting, and my wife is sitting over there and makes me go to it. But it's basically a rubber stamp of what the church council's already put together, right? But we do vote, makes us feel useful on whoever they put forward, and there is some value to, again, maintaining that sort of structure. I think more important though, personally I think, is the minutes that you would keep of the whatever it is, the church council or that group, because that's where the real action.
You can't avoid the annual meeting, kind of, if you're a corporation. If you're a corporation, you've got a board of directors of, say, 5 people.
Right,
They can take an action by unanimous consent.
right.
So if they want to lay out all the things that they believe that happened in the last year, and ratify the acts of the officers and do all that, they can do that as long as every director agrees, signs on, and makes unanimous consent. That being said, John's 100% correct. I don't think it's a good idea. I think it's better that that board sits down and actually talks together, goes over those issues. We do a lot of different types of corporations. If it's you and your wife who form a corporation to sell widgets, it's only the two of you, do you need to have an annual meeting and sit down and meet and hash this out? No, you can do it by unanimous consent.
Or do it in Maui and that works out.
Yeah, exactly. But just to do it with a larger group, by a church.
You gotta look at your bylaws, because if you're forming a corporation, you wanna think through all those kinds of issues. Do we want an annual meeting? Do we want to be able to have the church council meet online? There's all the different programs. I have a board that they're pretty geographically spread out. And so once a month, everybody plugs into GoToMeeting and everybody's there looking at each other, and it's voice activated, all that stuff. Or how do you want to structure it? Because if your bylaws require an annual meeting, you will have an annual meeting. If your bylaws don't require it, then you want to think through why you wouldn't want to do that, and then you can probably, and you can change your bylaws too. Bylaws can be modified depending on what the amendment process requires. 2/3 vote, 50%, whatever it's going to be. You have to.
In the past, we had, on a Sunday morning, the whole congregation was there, and we would include them. We had to have a quorum of over 50%.
Right.
Is that necessary? Or, like you said, that we just have the entire board?
It just strikes me that's awfully cumbersome.
Yeah.
First of all, I lower the quorums most of the time. If I have to do a vote of the membership,
Right.
whether it's the congregation membership or whatever membership I'm talking about in a nonprofit, I usually cut it as low as the legislature will allow me, right? Simply because most of the time it's going to simply be a consent to whatever the board feels it needs to put before the membership. If it's the board of, the leadership board, whether it's church council, board of directors, trustee, I was at Linfield for a lot of years, and we were the board of trustees, same thing as the board of directors, right? And so at that juncture, you do want to have a quorum, and you want to follow Robert's Rules of Order, at least the little part of it, not the big part. And so that's where you sit down with a group if you're just forming. Or you've realized, this has gotten way too cumbersome. So you sit down with somebody, you could be years in going, maybe in your case, and saying, we now have 4 entities that are interrelated in some way. We should sit down and maybe look at that, figure out, is this the best way that we can go forward? From an accountant's perspective, are we maximizing and protecting ourselves from a tax standpoint? What kinds of insurance issues are we creating by all of this? Should we have one umbrella policy or multiple policies? And then, of course, the lawyer can do whatever is necessary. One of the things I see about corporations a lot is they never go back and look. I have a couple of big companies, and they actually have committees that meet every other year. Not the same people, but the committee is formed every other year to double check and make sure the bylaws are still relevant to the corporate structure. Now, in that case, this particular organization has 12,000 members, and so that's necessary because there's so many people. But I don't know how big your churches are, but hopefully you'll get to that point. So
It's like the vote of the members, I think it's almost, so a nonprofit is run by its directors. There are no shareholders in a nonprofit. But the vote of the members of the church has always struck me as almost like a leftover thing from for-profit corporate law. It's like a vote of the shareholders.
Right.
So as long as that's not something that was put in the bylaws, which are the rules of the whole thing, no need to do it. If it is in the bylaws, I'd seriously look at changing that.
because the congregation is not going to necessarily be well informed.
Right.
And that's the bottom line. I mean, you can keep them informed, and frankly, having regular kinds of, whether it's by a newsletter or however you do it is because it's their congregation, right? And in terms of the earthly part of it, right? But you want to keep them informed, but to have them vote on anything more than, most of my companies, secular or not, have gone to slate voting, right? Because the membership votes, it becomes a popularity contest, which means some pretty bad people could get in. We're all seeing that right now, however you're political. We're all seeing that right now in our real government. But, at the church, it could become a popularity contest, and you know, at different times, you may need different gift mixes, right? Right now, we're forming, we need people that can plan, that can, you know, do this, but down the road, we're gonna need people that are more in a different kind of a gift mix so that we can grow and think about, you know, doing whatever the next step is. And so to me, the more flexibility you put into your bylaws, the better off.
I appreciate that. And we stopped doing the congregation involvement about 8 years ago, and so I
You're probably
make sure
growing,
we're
huh?
okay.
Yeah, I'm, like I said, she makes me go. But, and I love my church, I do. I love my pastor. And I was really worried about what was happening when the senior pastor decided to, you know, retire. But I'll never forget sitting down with him the second year. We have this annual thing where it's like a leadership summit kind of a thing, which is really actually pretty good. You know, where they spend the whole day talking about stuff, bringing in a guest speaker and all that. And I remember sitting in the back with our retiring senior pastor talking about our planned obsolescence. Right? Because that's really what you're talking about, is at some juncture, we all have to plan our own obsolescence. And that's where the succession planning, if your pastor's starting to get, you know. And also, succession planning for your church council, right? What kind of people are we looking, I mean, I have an organization that I represent that is very, very intentional about bringing in young people in the second tier of governance, you know, the committee structure. They actually call it the Young Professionals Network, right? And that's the way I can say, oh, she's pretty sharp. She's pretty sharp. Let's bring those people in and see how they do, and then put them on the board someday, because we have that mix of old and seasoned, or seasoned and new, I guess would be the way to say it. Right, so, any other questions? So, see if there's anything else we were supposed to.
I know we were talking at one point, Bob and I were talking a little bit about the question on 501c3 status. One of the issues that we hear a lot is this question about whether you should apply for 501c3 status. And I think there's some confusion in that area that maybe be a good idea to talk about, but every church, to be able to be considered a nonprofit church, is still going to have to meet those requirements under section 501c3 of the Internal Revenue Code. So, you know, you take a look at those things, and it's, you have a distinct legal existence, and you have a definite, distinct ecclesiastical government, and a formal code for doctrine and discipline, established place of worship, regular congregation, and regular religious services. So if you meet all those requirements, you're automatically exempt from taxation under the code. Now there's another step where you can apply to the IRS to be recognized as a 501c3 organization. And that's where I think the question comes in. Is that a good thing to do? Do we recommend it? The general answer for our firm is we do. And there's a reason for that. There's been a few cases that have come down that, there are a couple cases. Number one, there was a Jack Lane Taylor versus Commissioner case. And in that case, they basically said that if you have not applied to be recognized as a 501c3 organization, the burden is on the church to prove that they comply with all of those terms. If not, then it's like basically you're going to be treated as if you had not been a 501c3. The big issue with that is there was another case that came along later that said, well, if they determined that you were not acting as a church, that exemption would basically be stripped going back to the inception of the church. And whereas if you were a 501c3 registered and they said, hey, you're not operating as a church, that determination would go back to the year when you were first determined to be not functioning as a church. So, I mean, if you got 20 years of time that went by, and now all of a sudden, all of those years you were non-exempt, you can see where the problem would be in that.
And that's where piercing through the corporate veil becomes huge.
Well, back taxes.
It doesn't affect necessarily the people that have made the donation. Because if you in good faith make a donation to what appears to be a legitimate tax exempt entity, you're okay. If I write a check to a church and it turns out that they're set aside, I'm okay. If they challenge me, I have to establish that in good faith I believe it to be. But again, a lot of bigger donors are going to want to know you're a 501c3 for that reason. Right? They're not going to want to write a check on a bigger ticket item, you know, that can help fund your preschool or help pay for your land, or you're doing a capital campaign or something along those lines. So it just depends, I just think it makes sense, it's a lot of work. I don't know if you've ever seen, for those of you that have done it, you know what I'm talking about. Yeah, it's a huge amount of work. So make some of you don't like doing. But it's something I think is personally, I think worthwhile to do. This does create that.
Yeah, the other thing is, while you are automatically exempt under federal law, California doesn't do that. But
That's
as you know,
35.
California isn't a big lover of churches, but you've still got to register with the Attorney General. If you are an unincorporated association, let's say, and you go out and you choose not to get your 501c3 status, you have to fill out a Form 3500 with the state of California, which is this beefy, ridiculous form that will take you forever to go through. If you've got a 501c3 status with the federal government, and you go back to the state of California, you can do a 3500A, which is a real minimal form that basically says, here's who we are, we're already recognized as a 501c3, so you get to avoid a lot of the extra fun of getting to pay people like us to try to fill out your 3500.
I just think it's a valuable thing for you to do. Again, the goal is you're forming an entity to grow. I mean, that I would assume is the case most of the time. And so setting it up, it's like any other foundation, right? You build a house, you set it, you set it on a foundation, not of sand. And so these are the kinds of things from a secular standpoint. It's something that Todd just touched on. You know, Bob mentioned that we were in Sacramento last week for the California Association of Realtors. The week before that, I was also up there for another group, the Restaurant Association. And I got to tell you, politically, it's irrelevant. You know, we all have our views, but there's 2,700 bills being proposed right now, and 11 of them are significant tax bills. And as Todd mentioned, this state is not a real big fan of churches. We've all seen that in a lot of the laws they've passed. And so the more you can do to protect yourself, whether it's employment, whether it's taxation, whether it's corporate structure, I think you're going to make sense, because unfortunately, it's not going to change. It's not going to go away, I don't think. I saw hands go up. Yes, sir. Over there.
Can an association be covered under 501c3?
I don't know.
Yeah, they would be able to. I mean, again, there's difficulties with all of these things. I mean, an unincorporated association is just going to have a lot more difficulties because there's really no overarching, when you file a corporation, you have to file your articles of incorporation. Now you're actually recognized as this is the entity, whereas an unincorporated association, if all of us could form one, who's the person in charge? How are they voting? Who's responsible if things go bad? How does this organization wrap up if we decide we all want to go our separate ways? So there's a huge advantage to being an entity of some sort rather than going through that process as an association.
I'm representing 21 property owners right now in an issue regarding the Orange County Transportation Commission. It's like herding cats. To try and get them all on the same. Whereas if I had a corporation, I have 2 or 3 people I can go to who can make the decision, right? And so it's just a better decision-making function, it seems to me. Now, if I were sitting down with your buddies that are the association, I'd be asking them, what are your objections to forming a corporation? Because it's not very expensive, particularly if it's a relatively small entity. And once you do it, you're done, and you don't have to have all these side issues you have to worry about. Yes, sir, you had a question?
Yeah, you mentioned protecting yourself, and that is important with all the new laws coming down. One thing we did a couple years ago was to put together a policy statement. It's like 12, 15 pages long. Because, you could get approached by gay, lesbian groups who have weddings in your church and so on.
Mm-hmm.
We addressed that. We addressed discipline of certain members who were doing illegal things and how we handle those. And so, do you think that's a good idea in addition to
Absolutely.
bylaws?
It's a great idea, because again, going back to, again, I'm trying to stay away from the politics of it, but the reality is the LGBTQ, now it's called Q, group is very, very powerful in California. And so are the trial lawyers. And so they call themselves the consumer lawyers now, the dark side of the force. And they're very powerful in Sacramento. And again, if, it used to be, if you called yourself a church, it'd probably be okay. But now, any partnership you would enter, I know my church was looking at partnering with the Arts Council because we have a piece of property that's perfect for an amphitheater. Decided not to do it. Why? Because exactly what you just said. Now all of a sudden you open up that hole and, like at Linfield, for example, where there's not a requirement that you sign some type of article of faith, and, that creates issues for the Linfield hiring group. And so you have to look at that stuff all the time, and every year as the new law is passed, you gotta go back. This year, you're all looking at, if you have more than 5 employees, including independent contractors for the most part, you've gotta do sexual harassment training. So every year, they throw a little bit more on the pot, and there's 3 or 4 employment law bills that are, brewing that are probably gonna pass. So I just think having your biblical, clear articles of faith, or whatever you're calling it, I think is absolutely a great idea. And again, pointing specifically to the provisions of Scripture that support that position, whatever it might be. And then to remain consistent with that, because once you start creating exceptions, then you start getting yourself in this.
You could say, here's our policy, it's, the Bible, but to be more specific.
I've heard of it,
It
yeah.
helps.
No, I think, again, if your principles are biblical, a lot of churches have, gay issues, which are, again, very politically powerful. But then you may have other things about how you deal with disputes amongst the congregation, the Matthew issue. Then you have all that, whatever it might be, again, every church is different. And you adopt it periodically. One good thing is, if it's biblically based, you don't have to go back and see if it changed, right? But from that standpoint, I think that's really a good idea. What do you think?
I agree, and I believe that it should be in the bylaws.
Yep.
I mean, not rather than a standalone document. I think that ought to be, the recitals in your bylaws ought to say, we're a Bible-believing church. We believe that marriage is between a man and a woman, and those ought to, John's right, that should quote, where's that coming from? And this is what we believe. So therefore, if there's a challenge on that, they're going directly against religious freedom at that point, and
It's sad to say, but churches are on the defensive in California. And so, again, periodically, you need to be thinking about that stuff. I think that's a great idea, Todd, maybe modifying your I don't know how hard it would be to change your bylaws, but just attach them into your bylaws and make it another section of your bylaw. I think that's really a very good idea.
One of the things
Yes, ma'am.
One of the things that we do with callings, and we call staffing rather than hiring from the outside, is we have a covenant of faith, so that it's pretty thick. And all of our disclosures of our articles and of faith in our bylaws, and they have to initial that they agree to support the tenets of the faith at this particular thing regarding abortion, same-sex marriage, and things like that. So then they have an opt-out. If they choose, they can't comply, they shouldn't,
It's the top.
Yeah.
No, I think that's, I think that's a good idea. Because, I bet.
So that's a document along with your hire.
We have an employment application, it's
Okay, yeah.
standard, but we have it in our water system. Everything on all of our documents have our statement of faith and our bylaws, and then they sign a covenant of faith at the hire. So when you're onboarding, they're looking through a document that takes about 3 hours for the hiring process, and they get an option to either agree or have a conversation as to why they oppose our tenets of faith. And at that point, we oftentimes say, this is probably not a good fit for you, because we aren't going to compromise our faith, because we don't hire, we affirm the calling on someone's life to serve in Christ.
Exactly.
So
This is
even
after you even offer them employment though?
even with the intent,
You can
even
tell
with,
them that they're out of there?
yes, we give them the option to say they can't support our tenets of faith. That's a choice. But if you do accept the calling, you're going to uphold these tenets.
And I don't think it's a
No.
bad idea to let them know up front. I mean, California law is changing in terms of hiring. You point, there's that initial conversation where you're not allowed to ask certain questions about, you know, your salary and all that kind of stuff. And now there'll be a law regarding, you know, criminal background.
Yeah,
But again, if you put everything up front initially and tell them what they can expect, while you may not be able to ask certain questions up front, at least I understand, I'm going to be asked these questions. And now it becomes a question of, A, is it legal, and B, am I willing to, what do you call it, onboarding? Is that like?
but right now, we are protected. We have the religious freedom to say that we are a Christian church. We ascribe to the Bible as it is the word, the inerrant word of God. And so if you're gonna, to us, it's a calling anyway. It's not looking for a job. We don't hire people. We don't hire you because you need insurance or whatever. It's because you're gonna uphold the faith.
Right.
And so you need to be educated, trained, and committed to the
I
things
think-
that our church stands for.
More and more, we're gonna see California churches look to federal law for protection as opposed to state law. I don't have a crystal ball, but I'm guessing
Hope so.
based on, well, again, that could change next year. I mean, that could change, who knows what the future holds for this country. And we should all be praying about that. But for right now, California pretty clearly going down a certain road. And I don't see that road changing for the foreseeable future because of the way we've structured our election system. But the federal law, which has, you know, the freedom of religion stuff, and although we have a First Amendment, you know, the state is obligated, you know, the courts at the federal level are going to be interpreting them, I think, in a more liberal way, liberal for us.
Real briefly, on the, since we only have 8 or 9 minutes left, on this, it says something about subsidiary entities' use of LLCs, and I think we might have skipped over that. When would you want to use an LLC in a religious setting?
It depends upon, and I don't mean, I'm gonna answer your question, but it really does depend upon a lot of issues relating to tax. There's a thing called unrelated business income, okay? You might have something that isn't inherently related to the church. Maybe you own, well, I don't know what it would be in a church. I frankly never seen
We
it.
lease to a preschool, for instance.
Well, the preschool can, in our church, the preschool is actually deemed a ministry. Over half of the people, and we have 100 kids on the waiting
It's not
list.
necessary, we lease it to a separate.
But you could have done it separately, they chose not to.
Right.
Okay, and I don't disagree with that because it wasn't necessary. And you don't form all these entities just because you want to. But let's say you were forming a school and you really truly wanted to keep it separate because it could fail, you didn't want to have one bleed into the other. You could form either a corporation or a limited liability company depending upon what the accountant recommends from a tax standpoint. Both protect pretty much the same way. I think the corporation frankly offers a little more permanence. I know in my work a lot of limited liabilities get formed and then they dissolve shortly thereafter, you know, depending on the purpose of it. So you would want to look at it. That's where the business people on your board, you know, sit down with, you know, your business planning group, your accountant, your maybe your lawyer. The lawyer, we basically come in usually and mop up, right? I mean, whatever the accountant tells us to do, whatever the insurance company tells us to do, it's not that hard to do. I think frankly, from a new entity perspective, your accountants and your insurance people are at least as important, if not more important, than having a lawyer. But your lawyers, don't get me wrong, I think we're important.
Yeah, I agree. I mean, they're definitely, I mean, the liability protection is pretty much the same. The question is really a tax question because, I mean, you know, corporations get taxed. Minimum tax on a corporation is $800 a year. Minimum tax on an LLC can be a percentage of the gross income to the entity.
Right.
A
So,
religious corporation has no tax liability.
well, if you've got an unrelated income that they was talking about, let's say
You
the
will.
church owns a parking lot next door
Yeah.
that they're charging,
Right,
you
right.
know, $5 to park there.
Yeah.
You've got issues you need to be dealing with your CPAs.
And that may, you know, for income tax and for liability purposes, you would spin that off into a separate entity because the income from it is really not necessarily a religious, qualified income.
So to sum up, you would use an LLC if you wanted to segregate non-religious income from the religious purpose.
That's one reason, certainly.
Okay.
There's other reasons, but that would be, in Again, as you probably gathered, I'm not a big fan of LLCs for purposes that we're talking about today. I know they're not as permanent, they don't, provide the kinds of things we're talking about. For example, most people that have, been blessed have a provision in their estate planning documents for giving to their church. It's easier to do that from when there's a permanence in donating it to that corporation, and then that corporation you can tell them, I want you to use this money for that purpose, right? So I just think it's easier, not exclusive, but easier in a corporate structure. Again, if you're prepared to do the things that you need to do, but setting them up is not very expensive. I mean, less than $2,000 for most of the time, but it's going to be keeping them updated, having your annual meetings. If that's, I don't mean your annual meetings with with your congregation, but at least your planning sessions. I personally believe every organization, when it gets to a certain point, needs to have a strategic planning meeting. I know that I love October because that's when I get to go with my clients to strategic planning meetings, and they always go to cool places. And I mean, seriously, because I remember one time, and I'll leave you with this, a guy made a comment because some of the directors couldn't understand why we were doing this. And the facilitator looked at them and goes, what's your annual budget? About $8 million. Oh, would you spend $25,000 to figure out how to spend $8 million? And that really, because it just lays it out. I'm a big believer in planning. So I just think when you lay it out, it gives your staff it gives your staff benchmarks. Everybody knows where you're headed. Obviously, there's always going to be contingencies and things that come up, whatever that might be. But if you have an overall plan, if you're not just sort of, wandering around the desert, so to speak, then when those things do come up, it isn't that big a blow to your organization. And stuff is going to happen.